Good afternoon, everybody. Meeting to call to order. Mr. Truman, has anyone signed up for public comment? All right, everybody bear with me. My apologies in advance. We've got a Senate Finance hearing that's pending and we're actually up next. They're on the group right before us. So we're gonna have to take up something out of order here. And then we're gonna recess. Unfortunately, that's gonna put Ms. Miller, your work kind of hopefully later this afternoon, sooner rather than later. We'll see how many questions the Senate has. We certainly want to be available to answer all those questions. So with that, let's take up agenda item 10, board nominations.
Good afternoon, Chairman and Commissioners. For the record, Cherie Dudley with Workforce Development. Today, for your consideration, we have Workforce Board nominations for Capital Area. Staff recommends approval on the presented nominees, and I'm here to answer questions you may have.
Any comments or questions?
Madam Mayor,
Is there a motion?
I move that we accept the motion as presented.
I second the motion.
It's been moved and seconded and the motion is adopted. Thank you.
Thank you.
All right. Any executive director's report?
No, sir.
With that, I think we'll stand in recess until a date to be determined. How much lead time do you need, Mr. Trillman? Obviously, there's probably thousands of viewers out across Texas watching this broadcast right now. We want to make sure they know what time we'll be coming back in.
We will update the screen with about 15 minutes before
All
convening.
right. Thank you, everyone. Appreciate your forbearance and we'll see you soon. Okay, we're back in session. Let's take up agenda item 3. Any cases to reconsider under agenda item 3?
No, sir, no cases.
Thank you. Let's move to tax liability cases under agenda item 4. I believe we have no tax cases on docket 2 or 3 or 4. Is that
Correct, no cases.
No fair housing cases under agenda item 5.
Correct.
Under agenda item 6, we have no wage claim cases on dockets 2, 3, or 4 pulled for additional discussion.
Correct, none pulled, but you should have received the wage claim short form dissent list for dockets 2, 3, and 4.
I move we accept staff recommendations on the remaining wage claim cases on dockets 2, 3, and 4.
Yeah, second the chairman's motion, except for the cases on which I'm dissenting is reflected in the wage claim short form dissent list for dockets 2, 3, and 4.
I concur with the chairman's motion, except for those cases in which I am dissenting as reflected on a wage claim short form dissent list for docket 2, 3, and 4.
Motion passes with the exceptions noted.
Thank you.
Let's move to agenda item 7, consideration of unemployment insurance cases on docket 2. Please proceed when you're ready.
Case number 2952132, Commissioner Trevino.
The decision is not supportable. The underlying issue in this case is whether the claimant worked customary full-time hours. This case involves the issue of validity of claim and therefore falls within the exception to the timeliness rules in Rule 32I1. The claimant's AT appeal should be deemed timely and the case remanded for merits testimony. Reverse the AT, deem timely, and resubmit.
Just for clarification, sir, we would remand instead of resubmitting.
Yes, ma'am.
Thank you.
We should reverse the appeal tribunal decision regarding timeliness. Issues related to customary full-time hours fall under the types of cases fitting the validity of claim category and present a one-time exception under the timeliness rules. Thus, because the claimant's appeal should be deemed timely, we should reverse the AT decision, timely claimant appeal, and remand for merits testimony.
Reverse the AT, timely claim and appeal remand.
We will remand the case.
Case number 3006525, Commissioner Demerson.
We should reverse the appeal tribunal decision. The employer did not timely respond to the notice of maximum potential chargeback by NMPC because the employer relied on public messaging and believed that businesses would not be impacted by COVID job separations. In addition, as with other similar cases this year, we've held that lack of proper information can be just as misleading to a party as improper information that is given to a party. In this case, the employer was not told on the NMPC that it could have dealt with its claim volume problem simply sending TWC a spreadsheet of all the NMPCs that it needed to protest. That is an option that was available during the pandemic and should have been mentioned on the NMPC to help employers deal with the unprecedented situation. Accordingly, we should reverse the AT decision, timely response to the notice of maximum potential chargeback, and resubmit for merits testimony.
The AT decision is correct. The employer received a notice of maximum potential chargeback in a timely manner. The employer filed a late response because they misunderstood the requirements to file a response. There's no good cause exception to the timeliness rules. Affirm the AT. Late protest to the notice of maximum potential chargeback, charge the employer's account.
Reverse the AT, timely response to the NMPC, resubmit.
We will resubmit the case.
Case number 3161590, Commissioner Dimerson,
We should reverse the appeal tribunal decision. The employer has provided detailed and credible testimony of having submitted a timely response to the notice of maximum potential chargeback. Accordingly, we should reverse the AT decision, timely response to the notice of maximum potential chargeback, and resubmit for merits. In the alternative, we should rehear this case. In its appeal to the commission, the employer is offering to provide a copy of the notice it timely submitted, which bears a contemporaneous notation of the date it was mailed. Because such evidence is clearly relevant and should be considered before we render our decision, we should grant a rehearing in this case and instruct the employer to produce a copy of the notice.
The AT decision should be affirmed. The notice of maximum potential chargeback was mailed to the employer's correct address, received timely. While the employer has alleged sending a timely response that the agency never received, the employer did not provide firsthand testimony from a disinterested witness, nor physical evidence specifically linked to the alleged timely response. The employer therefore did not meet the evidentiary requirements for its response to be considered timely. From the AT late response to the notice of maximum potential chargeback, charge the employer's account.
Reverse the AT, timely response to the NMPC, resubmit.
We will resubmit the case.
case number 3233726, Commissioner Trevino,
The AD's decision is not supportable. The final incident did not rise to the level of misconduct connected with the work. As a supervisor, the claimant managed case workers' assignments. When a Spanish-speaking parent became more involved in the case after 9 months, the claimant made appropriate management decision to switch the assigned caseworker to a Spanish-speaking caseworker who would more effectively communicate with both parents. The employer admits that the claimant's supervisor's actions in the final incident did not violate any written policy. Reverse the AT decision, no misconduct, bill reimbursing employer's account, void adequate response.
The appeal tribunal decision should be modified. The claimant was discharged for poor job performance. The claimant had received a written warning which notified him that his job performance needed to improve. Moreover, the warning alerted the claimant that if his job performance did not improve, he could be dismissed. The employer also stated in testimony that the claimant had 40+ years of experience as a supervisor and had effectively performed his job before. Accordingly, the claimant's failure to improve his job performance was mismanagement of his position of employment and misconduct connected with the work. She therefore modified the AT decision. Misconduct, reimbursing employer not billed, sever adequate employer response.
Modify the AT, misconduct, reimbursing employer not billed, sever adequate response.
Short form dissent.
Yes, sir.
case number 3274291, Commissioner Trevino,
The AT decision is not supportable. The claimant was discharged for absences with notice on 4 days. The claimant was absent 1 day after the death of a family member. He was absent another day because he was personally ill. Finally, he was absent 2 days because of icy roads preventing him from driving to work. Since the claimant provided proper notice of each of his absences, and because he was absent due to these unavoidable situations, the claimant was discharged for reasons other than misconduct connected with work. Reverse the AT, no misconduct.
The appeal tribunal decision should be affirmed. In the nearly 3 weeks that the claimant was employed with the named employer, he was excessively absent. The employer reminded the claimant that he needed to be at work. Nonetheless, the claimant continued to be absent. As such, the claimant's actions constituted work-connected misconduct and we should affirm the AT decision misconduct.
Reverse the AT, no misconduct.
Short form dissent.
Yes, sir.
Case number 3300501, Commissioner Trevino,
The AT decision should be affirmed. The complainant was discharged for performance issues, and the employer confirmed that the claimant never met performance expectations. In accordance with commission precedents, the claimant's failure to meet expectations cannot be deemed misconduct because the claimant was never able to consistently meet the employer's performance standards. Affirm the AT, no misconduct, chargeback.
The appeal tribunal decision should be reversed. The claimant was discharged for poor job performance, which mainly consisted of the non-performance of job duties. After receiving a final warning, the claimant failed to improve. Regarding the claimant's workplace concerns, the claimant stated both in testimony and in its documentation that it investigated the claimant's allegations and found no basis to substantiate her claims. Since the claimant failed to improve her job performance after a final warning, she mismanaged her position of employment, amounting to work-connected misconduct. She therefore reversed the AT decision, misconduct, no chargeback, adequate employer response.
Reverse the AT, misconduct, no chargeback, adequate employer response.
Short form dissent.
Yes, sir.
case number 3302697, Commissioner Dimerson,
We should reverse the appeal tribunal decision. Because the employer ratified the separation from the client company, that separation should be the focus of our analysis. Whether the separation is viewed as a discharge or a quit, the claimant should be disqualified. The employer's witness testified that the claimant abandoned his job by not returning to the job site and by telling the owner he did not want to work for the company anymore. This would be a voluntary quit without good cause connected with the work. If viewed as a discharge by not completing his duties, delaying the completion of his job assignment, and by being a no-call, no-show, the claimant mismanaged his position of employment. In the absence of any testimony from the claimant, the employer has met its burden of proving that the claimant's separation resulted under disqualifying circumstances. We should reverse the AT decision, misconduct, no chargeback, adequate employer response.
The decision is correct. The claimant was charged by the client company for alleged failing to complete assignments. The complainant had not received any prior warnings. The employer has failed to provide sufficient evidence to establish misconduct connected with the work. Affirm the AT, no misconduct, chargeback.
Reverse the AT, misconduct, no chargeback, adequate employer response.
Short form dissent.
Yes, sir, Commissioner Trevino.
case number 3341474, Commissioner Trevino,
The decision is not correct. The employer required the claimant to abide by their client's COVID vaccine mandate. The mandate did not allow for exemptions for reasons of personal conscience. The claimant sought and received a temporary exemption for medical reasons. She communicated with the employer in an attempt to make her exemptions permanent, but the client company never provided the claimant with a permanent exemption. The claimant was effectively discharged in June of 2022 for not being vaccinated when her temporary exemption expired. The client's vaccine mandate was not in accordance with the governor's October 11th, 2021 order. Since the separation was related to the employer's attempt to address the pandemic, I can agree to protect the employer's account. Modify the AT, no misconduct, no chargeback disaster.
You agree with that? The appeal tribunal decision should be modified. The claimant was ultimately separated because of procedures that were implemented due to the pandemic. As such, the claimant should be qualified for benefits, but the employer's account should remain protected from chargeback due to disaster. Should therefore modify the AT decision, no misconduct, no chargeback disaster.
Reverse the AT, no misconduct, chargeback. Short form dissent.
Yes, sir, Mr. Chairman. And that was the last unemployment insurance case. Pulled for additional discussion on docket 2. You should have received the UI short form dissent list for docket 2.
I move we accept staff recommendations on the remaining UI cases on docket 2, except for the cases on which I am dissenting as reflected on the UI short form dissent list. for docket 2.
Now, I second the chairman's motion, except for the cases on which I am dissenting as reflected in the UI short form dissent list for docket 2.
I concur with the chairman's motion, except for those cases on which I am dissenting, as reflected on UI short form dissent list for docket 2.
Motion passes with the exceptions noted.
Thank you. Continuing to docket 3.
Case number 268-7631, Commissioner Trevino.
The AT decision is not supportable. With the employer, or while the employer is a PEO, the employer ratified the separation from the client company, and the claimant had no duty to report back to the employer for further work. The claimant had a family emergency in which 2 family members were hospitalized. The claimant received permission from the general manager to attend to the emergency and return with the appropriate medical documentation to support his absence. Within the week, the claimant sent the medical documentation and reported he was ready to return, but the owner refused to allow him to return. Because the claimant had permission to be absent and provided medical documentation, the claimant was discharged for reasons other than misconduct connected with the work. Reverse the AT decision, no misconduct, chargeback.
The appeal tribunal decision should be affirmed. The claimant left work due to personal reasons, and the evidence in this case does not establish that the claimant provided the employer a return to work date. As such, the claimant quit without work connected good cause, and we should affirm the AT decision. Voluntary leaving, no chargeback.
Reverse the AT, no misconduct, chargeback.
Short form dissent.
Yes, sir. Commissioner Demerson.
Thank you.
Case number 2854354, Commissioner Trevino.
The AT decision should be reversed. The determination was sent to the claimant's online UBS inbox on March 22nd, 2021. Due to technical problems, which were common at that time, the claimant was unable to log into his UBS account and was therefore unaware of the determination. He attempted to contact commission personnel for help, but could not reach anyone. He filed his appeal 2 days after the deadline. Since the claimant did not have adequate notice of the adverse determination due to circumstances beyond his control, his appeal should be deemed timely. Reverse the AT, timely AT appeal, and resubmit on the merits.
And the appeal tribunal decision should be reversed. The claimant's appeal should be dismissed because it was filed beyond the applicable deadline to do so. There are no good cause exceptions to the timeliness rules, and accordingly, we should reverse the AT decision, untimely claimant appeal, leave the underlying determinations in full force and effect, voluntary leaving, overpayment.
Was the AT decision, did they call the claimant appeal timely or untimely?
The appeal tribunal ruled the appeal timely.
All right. Reverse the AT, untimely claimant appeal, voluntary leaving, overpayment.
Short form dissent.
Yes, sir.
Case number 2864395, Commissioner Trevino.
The AT decision is not supportable. The claimant in this case had to sign a severance agreement in order to receive payment from the employer. The agreement the claimant had signed included a release of legal claims against the employer. The payments made to the claimant were consideration in exchange for the claimant's agreement to voluntarily relinquish substantial rights to the employer. Since the payments constituted consideration as part of such an agreement, they cannot constitute disqualifying severance pay. Reverse the AT, severance pay eligible, no overpayment.
The appeal tribunal decision should be modified. The claimant received 24 weeks of severance pay. The severance pay was not conditioned upon any of the non-disqualifying circumstances mentioned in section 207.049 of the Act. Because the severance pay covered 24 weeks, the claimant's disqualification period should reflect the same. Accordingly, we should modify the AT decision, severance disqualification from October 18, 2020 through April 3rd, 2021. Recalculate the overpayment.
Modify the AT, severance disqualification from October 18, 2020 through October 24th, 2020, recalculate overpayment.
We do not yet have a majority vote. The chairman has had 1 week of disqualification. Commissioner Demerson, you had 24 weeks of disqualification. And Commissioner Trevino, you did not disqualify at all.
Ma'am, I'll agree with the chair.
To 1 week of disqualification?
Agreed.
Thank you.
Short form dissent.
Yes, sir.
Thank you.
Case number 3055426, Commissioner Trevino.
The AT decision should be modified. The claimant on the workers' compensation was on workers' compensation due to an on-job accident. The employer contended that the claimant quit when he failed to report to the employer. However, the employer received a workers' compensation status report indicating that the claimant was off work under doctor's orders from 7/21/20 through 11/9/20 for spinal surgery and post-op rehab. The claimant provided the only firsthand testimony in the hearing that credibly established that he provided documentation that he would be off work to the plant manager. The claimant was discharged due to his medical condition and not for misconduct. Modify the AT, no misconduct, no chargeback due to MVI.
The appeal tribunal decision should be affirmed. Per the employer's response to the notice of claim, the claimant took paid time off during July 2020 and did not return back to work. The employer's testimony also reflects that the employer tried to contact the claimant, but was unsuccessful in doing so. Because the claimant failed to apprise the employer of when he would be returning to work, he voluntarily quit without good cause. We should therefore affirm the AT decision, voluntary leaving, no chargeback.
From the AT, voluntary leaving, no chargeback.
Short form dissent.
Yes, sir.
Case number 3206637, Commissioner Demerson.
The commission should grant a rehearing in this case. Per the AT decision, the claimant had worked with the employer since 2018. Commission records reflect that the employer reported wages from the claimant until at least the third quarter of 2020. Since the claimant appears to have been working in the same capacity with the employer, albeit in separate stints, the total amount of hours he worked for the employer since 2018 should be combined to establish whether he worked for more than 4 weeks. This analysis would allow the commission to make a better determination on whether section 207.045 G-1 applies to this case. Accordingly, we should rehear this case to gather testimony from the employer regarding how many hours total the claimant worked since his hire date in 2018.
The decision is not supportable. The claimant was performing work for this employer periodically. From the time he had filed his initial claim, the claimant had only performed work for 1 week. As such, 207.045 G1 is applicable. The work paid less than his maximum wage demand and was therefore not suitable. The claimant is eligible for benefits under section 207.045 G1 of the Act. Reverse the AT, no voluntary leaving, no overpayment.
Reverse the AT, no voluntary leaving under chapter 207, section 045 G1, no overpayment. Memo to investigate possible unreported earnings.
Short form dissent.
Yes, sir, Commissioner Demerson, and we will send the memo, sir.
Case number 3210425, Commissioner Trevino.
The AT decision should be modified. The claimant was absent from work because she had COVID. Her firsthand testimony and documentation show that she was in contact with her supervisor, who told the claimant that he would submit her medical leave. The employer also admitted that she called the attendance line every day while she was absent. The claimant was told that she was on medical leave, but her supervisor apparently did not submit paperwork as he had represented that he would do. The claimant was discharged for reasons other than misconduct connected with the work. Because the claimant's separation was caused by her illness, I would also agree to protect the employer's account from chargeback due to MVI. Modify the AT, no misconduct, no chargeback due to MVI.
Agree with that. We should modify the appeal tribunal decision. Claimant was separated due to absences from personal illnesses with proper notice to the employer. Accordingly, the claimant should be qualified for benefits and the employer's account should be protected from charge under medical separation analysis. We should modify the AT decision, no misconduct, no chargeback, MVI, avoid the adequate response issue.
Modify the 18, no misconduct, no chargeback, MVI, void adequate response.
Thank you. And in order to make it unanimous, I would need a vote from you on the adequate response issue. Because you're reversing, it would be appropriate to void the adequate response. I don't believe you stated a vote on that issue before. I just need one on the record.
Right. We'll void the adequate response.
Thank you, sir.
Thank you.
We have a unanimous decision.
Case number 3219562, Commissioner Trevino.
The decision is not supportable. The claimant was discharged because he continued to make complaints about work-related matters. There is no evidence the employer addressed the complaints or told the claimant he would be discharged for continuing to make complaints. The complainant was discharged for reasons other than misconduct. Reverse the AT, no misconduct.
We should affirm the appeal tribunal decision. The claimant testified that he was loudly arguing with the apprentices on his last day of work. He also agreed that the employer's version of the events was a fair representation of the events on his last day. Because the employer had spoken to the claimant about his excessive complaining and the claimant continued to complain and created a disruption at work by arguing with employees over whom he had no authority, the claimant mismanaged his position of employment. We should affirm the AT decision, misconduct.
Affirm the AT, misconduct.
Short form dissent.
Yes, sir.
Case number 3293200, Commissioner Dimerson.
We should reverse the appeal tribunal decision. The claimant requested a part-time or reduced position based on the increase in her workload. The employer offered and the claimant accepted a PRN position, which did not guarantee any hours. In accordance with the commission president, because the change in position was based on the claimant's request, any periods of unemployment are attributable to the claimant under disqualifying circumstances. Thus, we should reverse the AT decision, voluntary leaving, no chargeback, adequate employer response.
The AT decision is supportable. The employer changed the claimant's hiring agreement by doubling the amount of work she was expected to perform each day and by denying the claimant's time off request. Because the employer materially altered the hiring agreement, the claimant left with good cause connected with the work. Affirm the AT decision, no voluntary leaving, chargeback. In the alternative, the claimant resigned because the increased workload was making her ill. Modify the AT decision, no voluntary leaving, no chargeback, MVI.
Affirm the 18, no voluntary leaving, chargeback.
Chair, I'm going to agree with Commissioner Trevino. Or let me hear his last vote, the MVI vote.
All right, we have one vote either way. You are the person who voiced both options. Which option do you want to go with?
I would go with the affirm the AT decision, no voluntary leaving, chargeback.
So I'm going to short form dissent then.
Yes, sir.
Okay, thank you.
Case number 3302462, Commissioner Dimerson.
The appeal tribunal decision should be reversed. The claimant was discharged as a result of a customer complaint. The AT decision states that an associate described as the claimant was yelling across the store to another coworker using curse words and acting strange. The claimant did not provide firsthand testimony under oath disputing the allegation since he did not appear at the hearing. As such, the employer's testimony combined with the AT's finding of fact are adequate to establish a preponderance of the evidence that the claimant engaged in unprofessional behavior amounting to work-connected misconduct. We should therefore reverse the AT decision, misconduct, no chargeback, adequate employer response.
The AT decision is supportable. The employer discharged the claimant and the employer has the burden to prove that the claimant committed misconduct connected with the work. Here, the employer only submitted a vague description of a customer complaint over the phone about an employee. There was no evidence presented to the identity of the claimant as the employee in the customer's complaint, and they did not allow the claimant an opportunity to contest the alleged complaint before discharging him. The employer has presented insufficient evidence that the claimant committed misconduct. Affirm the AT decision, no misconduct, chargeback.
Affirm the AT, no misconduct, chargeback.
Short form dissent.
Yes, sir, Commissioner Dimerson.
Thank you.
Case number 3303971, Commissioner Trevino.
The AT decision should be reversed. The claimant has consistently maintained that she contacted the employer for reassignment on the following business day by going to the employer's site and meeting with the recruiter about reassignment. The employer had no firsthand testimony to contradict the claimant's testimony. While the employer argues that the claimant did not sign a sign-in sheet, the employer's reporting policy does not require signing a log or a sign-in sheet. The claimant credibly testified that she did not know about a sign-in sheet. The claimant reported for another work assignment and was not offered further work. She was therefore involuntarily separated for non-disqualifying reasons. Reverse the AT, no misconduct, chargeback, void adequate response.
We should modify the appeal tribunal decision. The evidence of whether the claimant reported back for reassignment as required is in dispute. However, the employer provided a copy of the sign-in log that is signed by everyone who comes into the office, and the claimant's name was not on it for the date in question. As such, credits should be given to the employer's evidence. Therefore, because the preponderance of the evidence established that the claimant did not report back as required, she is considered to have quit without good cause connected with the work. She modified the AT decision, voluntary leaving, no chargeback, sever the adequate response issue.
Modify the AT, voluntary leaving, no chargeback, sever adequate response.
Short form dissent.
Yes, sir. And that was the last UI case pulled for additional discussion on docket 3. You should have received the UI short form dissent list for docket 3.
I move we accept staff recommendations on the remaining UI cases on docket 3.
Now, second the chairman's motion, except for the cases on which I'm dissenting is reflected in the UI short form dissent list for docket 3.
I concur with Chairman's motion, except for those cases on which I am dissenting, as reflected on UI short form dissent list for docket 3.
Motion passes with the exceptions noted.
Thank you. Proceeding to docket 4.
Case number 2849631, Commissioner Dimerson.
The appeal tribunal decision should be affirmed. The claimant filed her appeal beyond the applicable deadline to do so. Also, the claimant stated that she did not update her address with the commission. There are no good cause exceptions to the timeliness rules. Accordingly, we should affirm the AT decision, late claimant Rule 16 petition to reopen, leave the underlying decision in full force and effect.
The AT decision should be reversed. The delay between when the employer filed their appeal and when the appeal tribunal set the first hearing and when then mailed the first decision was excessive. The claimant has no longer filing a payment request and did not know that she had to keep her address updated with TWC. She had put in forwarding requests with the post office. As such, her petition was reopened and was timely, and she had a good cause for missing the first AT hearing. Regarding the separation, at the time of the first or of the final incident, the claimant was not aware that her job was in jeopardy. The final incident was a small mistake that was easily corrected and does not constitute misconduct connected with work. Reverse the AT, timely petition to reopen, good cause, no misconduct, chargeback, and void adequate response.
Reverse the AT, timely petition to reopen, claimant established good cause for AT1, no misconduct, chargeback, void adequate response.
Short form dissent.
Yes, sir.
Thank you.
Case number 2889942, Commissioner Trevino.
The claimant did not appear at the first hearing because he did not receive notice. Regarding the job separation, the decision is not correct. The claimant was discharged for allegedly not working for 3 consecutive days without notice. The claimant has provided firsthand testimony that he was performing tasks for the employer, attempting to close large deals, and that he was approved to take the 3rd day off. The employer admitted they only tracked work performed on their equipment and did not dispute the claimant was approved to be off on the 3rd day. The employer has failed to provide sufficient evidence of misconduct. Modify the AT, good cause, valid claim, no misconduct, chargeback, void adequate response.
We should modify the appeal tribunal decision. First, I do not dispute the good cause issue. Second, I agree that the claimant filed a valid claim. Concerning the job separation, during a conversation between the claimant and the employer, the claimant indicated his intent to resign. The claimant thereafter failed to perform further services for 3 consecutive days, which led to his termination. Although the claimant contends that he attempted to rescind his resignation and perform services for the employer during the 3 days in question, the claimant failed to present clear evidence that he performed any work. Since the claimant failed to perform work after asserting his intent to resign, the claimant's conduct was mismanagement of his position of employment, which amounted to misconduct. Hence, we should modify the AT decision. The claimant established good cause for missing the AT1 hearing, valid initial claim, misconduct, no chargeback, sever the adequate employer response.
Modify the AT, claimant established good cause for AT1, valid claim, misconduct, no chargeback, sever adequate response.
Short form dissent.
Yes, sir.
Case number 2898114, Commissioner Dimerson.
We should modify the appeal tribunal decision. First, I do not dispute that the claimant filed a timely petition to reopen and that he established good cause for his non-appearance. Concerning the job separation, the claimant was discharged for a violation of the timekeeping policies. He was clocking in at home while taking his temperature for the employer's COVID health check, and then arriving at work after he had clocked in. The claimant alleged that he believed that taking his temperature constituted compensable work. However, this is neither reasonable nor persuasive. Because the claimant clocked in while at home and misrepresented his time worked on multiple occasions, he violated the employer's timekeeping policies and was discharged for misconduct connected with work. We should modify the AT decision, timely Rule 16 petition to reopen. The claimant had good cause for missing the AT1, misconduct, no chargeback.
The decision is not correct. Regarding the timeliness issue, the claimant credibly testified that he did not receive the first AT decision because it was delivered to his neighbor's mailbox. Since the delay was due to a missed delivery, the claimant's appeal should be deemed timely. Regarding good cause, the claimant missed the hearing due to an unexpected family emergency involving his minor child. The claimant has good cause for his non-appearance. Regarding the separation, the claimant reasonably believed he was to clock in and perform, and when performing tasks required of him by the employer, such as taking his temperature before coming into work. There is no policy that prohibits this, and the employer did not inform the claimant that when he was clocking in incorrectly until they fired him without prior warning. Therefore, the employer did not establish that the claimant was discharged for misconduct connected with work. Reverse the AT, timely petition to reopen, good cause, no misconduct, chargeback.
Reverse the AT, timely petition to reopen, claimant established good cause for AT1, misconduct, no chargeback.
Short form dissent.
Yes, sir. Commissioner Trevino.
Case number 2978475, Commissioner Dimerson.
The employer's appeal to the commission should be deemed timely. The employer received the AT decision on the final day of the deadline. As such, the employer was allowed only a fraction of the normal 14-day appeal window to file its appeal. Having a single day to appeal a document that normally carries a 14-day appeal window is unreasonable, and accordingly, the employer's appeal should be deemed timely. We should therefore find that the employer filed a timely CA appeal, resubmit.
Although receipt of a TWC document on the final day of appeal deadline could constitute an exception to the timeliness rules, the employer here has not clearly established the document was received on the final day. The employer's witness was only able to provide that it was scanned into the employer's representation firm on the final day of the deadline. As such, the employer appeal should be dismissed as late. Dismiss the employer's appeal as late. The AT2 decision is left in full force and effect.
Timely commission appeal, resubmit.
We will resubmit the case.
Case number 3032697, Commissioner Dimerson,
The appeal tribunal decision should be reversed. The claimant was discharged due to poor performance. As the only party to provide testimony under oath at the appeal hearing, the employer stated that the claimant was not nice to clients and did not follow the work schedule. Not being nice to clients is not in the employer's best interest, and not following the work schedule amounts to a failure to follow instructions. It is not unreasonable to conclude that both of these actions were within the claimant's power to control. As such, the employer established misconduct connected with the work. Additionally, since the claimant did not appear for the hearing, the employer's testimony should be given greater weight. We should therefore reverse the AT decision, misconduct, no chargeback, adequate employer response.
The AT decision should be affirmed. The claimant never demonstrated the ability to perform the employer's satisfaction, which is not misconduct connected to work. Affirm the AT, no misconduct, chargeback.
Affirm the AT, no misconduct, chargeback.
Short form dissent.
Yes, sir.
Thank you.
case number 3171209, Commissioner Trevino.
The AT decision should be reversed. The claimant was partially self-employed and submitted evidence of messaging from the commission to which instructed the public that through the work search requirements were being reinstated, self-employment individuals who intended to reopen their businesses did not need to complete work search activities, but only needed to take steps to reopen their business. Based on the information from the commission, the claimant did not keep track of his work search activities, although he completed them. The claimant should not be held ineligible because he failed to keep track of his work search activities due to the reliance on the commission's information. Reverse the AT, work search eligible.
The AT decision is supportable. The claimant was both self-employed and an employee of others. He had been informed of the need to keep records of any work searches he did, which would include searching for work as a self-employed individual. Keeping at least some minimal records of work search activities while claiming benefits is not too much to ask. Although he reported some earnings during the weeks in question, he kept no records and could offer no details about whatever work resulted in those earnings. Accordingly, we should affirm the AT decision. The claimant was ineligible for PEUC benefits from June 6th through the 19th, 2021, due to making an insufficient search for work.
Affirm the AT, work search not eligible June 6, 2021 through June 12, 2021, and June 13th, 2021 through June 19th, 2021.
One moment, please. Not eligible June 6th through June 19th, 2021 is the majority vote.
Yes, ma'am.
So the claimant is not eligible from June 6th through June 19th, 2021.
Okay, short form dissent.
Yes, sir.
Case number 3171217, Commissioner Trevino.
The AT decision should be reversed. The claimant was partially self-employed and submitted evidence of messaging from the commission, which instructed the public that the work search requirements were being reinstated. Self-employed individuals who intended to reopen their businesses did not need to complete work search activities, but only needed to take steps to reopen their business. Based on that information from the commission, the claimant did not keep track of his work search activities, though he completed them. The claimant should not be held ineligible because he failed to keep track of his work search activities due to his reliance on commission information. Reverse the AT, work search eligible.
The AT decision is supportable. Just as in the preceding companion case, the claimant was both self-employed and an employee of others. He had been informed of the need to keep records of any work searches he did, which would include searching for work as a self-employed individual. Keeping at least some minimal records of work search activities are records of which work he did for which client while claiming benefits, again, is not too much to ask. Although he reported some earnings during the weeks in question, he kept no records and could offer no details about whatever work resulted in those earnings. Accordingly, we should affirm the AT decision. The claimant was ineligible for PEUC benefits from June 20th through the 26th, 2021, due to making an insufficient search for work.
Affirm the AT work search not eligible June 20th, 2021 through June 26th, 2021.
Short form dissent.
Yes, sir.
Case number 3189031, Commissioner Demerson.
The commission should grant a rehearing in this case. The employer requested to add a witness during the hearing, but attempts to reach the witness were unsuccessful. In addition, in its appeal to the commission, the employer states that it would like to provide testimony from its district manager who knew exactly what occurred with the claimant in this case. We should therefore rehear this case to allow the employer to present testimony from its witnesses.
The AT decision should be affirmed. The employer is not entitled to another hearing because they failed to provide a compelling reason why the district manager did not appear at the AT hearing. Regarding the chargeback issue, the employer provided 3 different reasons why the claimant's employment ended. The first reason the employer provided, which was the claimant was laid off due to lack of work, is the most credible because it was given to the commission before the employer realized their account would be charged. Since the claimant was discharged for reasons other than misconduct connected with work, the employer's account should remain subject to chargeback. Affirm the AT decision, chargeback.
Rehear.
We will rehear the case.
Case number 3190691, Commissioner Demerson.
This case should be remanded to the appeal tribunal. One of the employer's witnesses was not questioned, and the claimant was not fully questioned about all of the employer's allegations of misconduct. In addition, the employer's representative was not asked if they had questions for the claimant after the claimant's rebuttal testimony. These are issues that need to be cleared before the commission can render a proper decision in this case. Accordingly, we should remand this case for the reasons so stated.
The decision is supportable. The employer has presented primarily secondhand evidence that the claimant did not follow her supervisor's instruction or she was dishonest. The claimant has provided firsthand testimony that she followed all directives. The employer has failed to provide evidence of misconduct. Affirm the AT, no misconduct. Bill employer.
Remand to cure the due process violations.
We will remand the case. Did you wish to dissent?
Short form dissent.
Yes, sir.
Case number 3199314, Commissioner Trevino.
The AT decision is not supportable. Section 207.045H is not applicable in this case because the claimant was not informed of her benefits, or the benefits could be denied if she did not report back to the temporary help firm for further work. The claimant was employed for less than 4 weeks and receiving UI benefits when she accepted the assignment. The claimant's assignment was not suitable because the claimant's knee injury prevented her from standing to perform the work. When the claimant asked for an accommodation to sit, she was told to leave. As the claimant's physical fitness prevented her from performing the work The work was not suitable for the claimant under section 207.008 of the Act. As such, under section 207.045 G1 of the Act, the claimant is not disqualified for benefits. Reverse the AT, no voluntary leaving, no overpayment.
We should modify the appeal tribunal decision. The evidence of whether the claimant reported back for reassignment as required is in dispute. However, the employer provided a copy of the sign-in log that is signed by everyone who comes into the office, and the claimant's name was not on it for the date in question. As such, credence should be given to the employer's evidence. Therefore, because the preponderance of the evidence established that the claimant did not report back as required, she is required to have quit without good cause connected with the work. Should modify the AT decision, voluntary leaving, no chargeback, sever the adequate response issue.
This was case number 3199314.
Case number 10. Yeah, I think we had number 10 on docket 3. So let me read into the record for docket 4.
Thank you.
In the case I have is 3199314.
Yes, sir.
Okay. We should affirm the appeal tribunal decision. The claimant should be disqualified from receiving benefits under section 207.045 H of the Act. The record suggests that the claimant was required to contact the employer, a temporary help firm, upon the completion of a work assignment. The claimant failed to contact the employer or correspond with the employer when the employer attempted to communicate with the claimant. Since the claimant failed to contact the employer upon the completion of a work assignment, the claimant's separation entailed a voluntary quit without work-connected good cause. Finally, the record shows that the claimant's job was suitable per section 207.045 G-1 of the Act. As such, we should affirm the AT decision, voluntary leaving overpayment of $1,111.
Reverse the AT, no misconduct, no overpayment.
We have majority vote that the claimant should be granted benefits, but the sections of law differ. Mr. Chairman, you said no misconduct, and Commissioner Trevino, you said no voluntary leaving.
Yes, ma'am, I'll agree with the chair.
Thank you. And the overpayment also reversed, sir? Thank you.
Short form dissent.
Yes, sir, Commissioner Demerson.
Thank you.
Case number 3215771, Commissioner Trevino.
The claimant was placed in her position with the client company by a recruiter from the employer, a temporary help firm. The claimant was released by the client company. The claimant immediately spoke with her recruiter and asked about other positions, but was not offered another position. The claimant continued to contact her recruiter on a regular basis to seek further positions. Therefore, the claimant was laid off due to lack of work. When having made herself available for reassignment with her recruiter, no further work was offered. Modify the AT, no misconduct, void chargeback.
We should affirm the appeal tribunal decision. The claimant acknowledged the employer's rules, which required her to contact the employer's local branch upon the completion of a work assignment. Although the claimant alleged that she attempted to correspond with the recruiters for the employer's affiliated company, the record shows that the claimant failed to abide by the employer's specific instructions for reporting availability. Since the claimant acknowledged the employer's rules for reporting, but thereafter failed to follow the employer's instructions, the claimant's conduct constituted a voluntary quit without work-connected good cause. Since we should affirm the AT decision, voluntary leaving, void the no chargeback ruling.
Affirm the AT, voluntary leaving, void chargeback ruling.
Short form dissent.
Yes, sir.
Case number 3216795, Commissioner Demerson.
We should modify the appeal tribunal decision. First, I agree that the employer established good cause for its non-appearance and that the claim was valid. Concerning the job separation, the claimant submitted her resignation several months in advance based on her decision to retire. Although the employer accepted the claimant's resignation early, the employer paid the claimant through the end of her notice period. Under these circumstances, in accordance with Commission President, the job separation was initiated by the claimant, not the employer. Since the separation falls under Section 207.045 of the Act, the analysis shifts as to whether the claimant had good cause connected with the work to quit. Because the claimant quit in order to retire, she quit for personal reasons. As such, she should be disqualified from the receipt of benefits. We should modify the AT decision. The employer had good cause for its non-appearance, valid claim, voluntary leaving, no chargeback, and adequate employer response.
The decision is correct. I do not contest the employer had good cause issue. The claimant filed a valid initial claim. Regarding the separation on October 2021, the claimant provided written notice of her intent to retire on July 15, 2022. The firsthand evidence presented established that the employer told the claimant on March 14, 2022, that it would be her last day. In order to receive the severance offer from the employer, the claimant had to sign a separation agreement on March 14, 2022. The claimant was told that refusal to sign the separation agreement on March 14, 2022 would result in termination. Therefore, the employer initiated the work separation on March 14, 2022 for reasons other than misconduct. Affirm the AT, good cause, valid claim, no misconduct, chargeback.
Modify the AT. Employer established good cause for 81, valid claim, voluntary leaving, no chargeback, adequate employer response.
Short form dissent.
Yes, sir, Commissioner Trevino.
Case number 3226146, Commissioner Trevino.
The decision is correct. The claimant had good cause for missing the first hearing and should remain qualified for benefits because she left work due to medical illness or issues. Regarding the ability issue, while the claimant could not work with children, she testified she was able to perform other types of work. The claimant's medical documentation clearly establishes the issue was limited to her work with children, and her medical restrictions were not such that it would have precluded her from other types of work. Affirm the AT, good cause, no voluntary leaving, bill reimbursing employer, claimant is able to work.
We should modify the appeal tribunal decision. First, I did not contest the good cause issue. Concerning the job separation, the claimant was on approved leave with the employer and was advised to provide additional documentation for the extension of her leave. The claimant failed to provide the requested documents and submitted her resignation. Since the claimant failed to protect her job and quit when continued work was available with the employer, her separation constituted a voluntary quit without work-connected good cause. Concerning the claimant's ability to work, the claimant failed to submit any medical documentation which affirmatively established that she was released for full-time work. Hence, we should modify the AT decision. The claimant established good cause for missing the AT1 hearing, voluntary leaving, reimbursing employer not billed, adequate employer response, ability not eligible beginning January 9, 2022.
Affirm the AT. Claim established good cause for 81, no voluntary leaving, bill reimbursing employer, claimant able to work.
Short form dissent.
Yes, sir.
Thank you.
Case number 3228895, Commissioner Demerson.
The appeal tribunal decision should be reversed. The events in this case took place before the governor's executive order dated October 11, 2021. The claimant was discharged under the employer's vaccination policy. The policy provided religious and medical exemptions from getting the vaccine, but the claimant did not apply for any exemptions. As such, the equivalent of misconduct was established by the employer. We should therefore reverse the AT decision, misconduct, reimbursing employer not billed, adequate employer response.
The AT decision should be affirmed. The employer's COVID-19 vaccine mandate was a significant change to the claimant's hiring agreement. While the employer offered medical and religious exemptions, they did not offer personal conscious exemptions. so the claimant did not apply for an exemption. Since the claimant was discharged due to a COVID-19 vaccine requirement, she was discharged for reasons other than misconduct connected with work. Affirm the AT decision, no misconduct, bill the employer's reimbursing account.
Reverse the AT, voluntary leaving, reimbursing employer, not billed, adequate employer response.
We have a majority vote, but the sections of law differ.
I'm going to agree with the chairman.
Okay, majority vote is voluntary leaving, reimbursing employer not billed, adequate employer response. So the claimant is disqualified.
Okay, short form dissent.
Thank you.
Case number 3236946, Commissioner Trevino.
The claimant's change of address during the appeal period constitutes a timely appeal. Regarding the job separation, the claimant was sent home after she had a mental breakdown after months of harassment by her supervisor and some recent personal issues. The claimant attempted to return to work after she was sent home, but was not allowed to return without the release from a specialist. And although the claimant tried to make an appointment to obtain that release, she could not get an appointment before her paid sick time had been depleted. The claimant therefore quit due to a medically verifiable illness, which constitutes good cause connected with the work. Timely appeal, no voluntary leaving, void reimbursement ruling.
First, I do not contest the claimant's appeal to the commission was timely. Concerning the job separation, we should affirm the AT decision. Although the claimant alleged displeasure with her working conditions, she failed to address her concerns or afford the employer an opportunity to resolve her dissatisfaction prior to quitting. Not only did the claimant fail to adhere to the employer's specific instructions to be evaluated by a doctor prior to returning to work, she also failed to contact HR or pursue other options prior to her resignation. As such, the claimant's separation constituted a voluntary quit without work-connected good cause. Therefore, we should deem the claimant's appeal to the commission as timely, affirm the AT decision, voluntary leaving, void the reimbursement ruling.
Timely commission appeal. Affirm the AT, voluntary leaving, void reimbursement ruling.
Short form dissent.
Yes, sir.
Case number 3258364, Commissioner Trevino.
The AT decision is not supportable. The claimant denied under oath the allegations of misconduct. The employer only presented secondhand hearsay evidence to prove the allegations of misconduct. As such, the employer presented insufficient evidence to prove that the claimant was discharged for misconduct connected with the work. Reverse the AT, no misconduct, chargeback, void adequate response.
The appeal tribunal decision should be modified. The claimant was fired for violating the employer's policy about respect for individuals. The employer explained that the claimant was given progressive discipline and that any further policy violations would lead to discharge. Nonetheless, the documentation in the record shows that the claimant made a comment that was disrespectful towards another worker in front of other associates. As such, the claimant mismanaged his position of employment. We should therefore modify the AT decision, misconduct, no chargeback, sever the adequate response, employer response.
Reverse the AT. No misconduct, chargeback, void adequate response.
Short form dissent.
Yes, sir.
Case number 3294650, Commissioner Trevino.
The AT decision is not supportable. The claimant presented a doctor's note that the claimant's health condition required her to be transferred to a different building without mold problem. The employer was unable to accommodate the claimant's transfer request. The claimant took all responsible efforts to protect her job, but ultimately, the claimant had to quit due to her medically verifiable illness. The AT decision should be reversed. No voluntary leaving, MVI. Bill the employer's reimbursing account, void adequate response.
We should modify the appeal tribunal decision. The claimant was discharged for excessive absences and not returning to the workplace at the expiration of her approved leave. The employer addressed the claimant's workplace concerns, tested the work site for mold, and provided the claimant with approved leave when needed. Ultimately, the test results revealed that the work site mold levels were within allowable limits. Because the claimant did not return to work after the end of her leave, she mismanaged her position of employment. We should modify the AT decision, misconduct, reimburse an employer not billed, sever the adequate response issue.
Reverse the AT, no misconduct, bill reimbursing employer, void adequate response.
We have a majority vote that the claimant should be granted benefits, but the sections of law are different. The chairman voted that there was no misconduct, but you, Commissioner Trevino, you voted under a quit rationale.
Yes, ma'am, I'll agree with the chair.
Thank you.
Mhm.
And Commissioner Dimerson, did you wish to?
Short form dissent.
Yes, sir. Thank you.
Case number 3294688. Commissioner Dimerson,
We should modify the appeal tribunal decision. First, I agree that the employer's appeals to the determinations in question should be deemed timely and that the claim is valid. As to the job separation, the employer suspended the claimant without pay after the client reported that the claimant had threatened her with a gun. The employer reported the allegation of abuse to Adult Protective Services as required. For the safety of its clients, the employer could not reasonably keep the claimant working while the state investigated the matter. Under these circumstances, since the reason for the claimant's job separation was urgent, compelling, and necessary, the claimant should remain qualified for benefits and the employer's account should be protected from charge. We should modify the AT decision. The employer filed a timely appeal, valid claim, no misconduct, no chargeback. The separation was urgent, compelling, and necessary.
Okay, I'll agree with Commissioner Dimerson.
Thank you.
Modify the AT, timely employer appeal, valid claim, no misconduct, no chargeback, urgent and compelling.
I'm sorry, I didn't catch the last part of that after valid claim.
So the whole rest of it, no misconduct, no chargeback, urgent and compelling.
Urgent and compelling. Okay, so you're agreeing with Commissioner Dimerson as well?
I mean, I don't like to admit that publicly, but yes.
Okay, thank you. We have a unanimous decision.
case number 3299600. Commissioner Dimerson,
The appeal tribunal decision should be reversed. The claimant was discharged due to poor job performance. Specifically, the final incident related to the claimant violating safety rules. The employer testified that the claimant was directing a forklift driver to move steel in an unsafe way. The claimant did not provide testimony to the contrary. Since safety rules are instituted to protect the well-being of others at the workplace, the claimant's violation of such rules constituted work-connected misconduct. We should therefore reverse the AT decision, misconduct, no chargeback, adequate employer response.
The decision is correct. The claimant was discharged for performance issues. The evidence established that the claimant never demonstrated the ability to meet the employer's work standards. In accordance with Commission's precedent, the claimant inability to ever meet with the employer's performance expectations does not constitute misconduct connected with the work. Affirm the AT, no misconduct, chargeback.
Reverse the AT, misconduct, no chargeback, adequate employer response.
Short form dissent, ma'am.
Yes, sir.
case number 3300884. Commissioner Trevino,
The AT decision is not supportable. The claimant was discharged for a violation of the attendance policy, and the employer alleged the claimant had repeated no call, no shows. The claimant testified that she provided notice of to the employer whenever she missed work, and that most of her attendance issues were caused by having to miss work to care for her minor child who has special needs and to take her to doctor's appointments. The employer did not appear at the hearing to provide testimony and failed to establish that the claimant was discharged for misconduct connected with work. Since the claimant's absences were due to medical issues involving her minor child, I can agree to protect the employer's account from charge. Reverse the AT, no misconduct, no chargeback, MVI.
We should affirm the appeal tribunal decision. Despite having received several warnings for attendance, including a final warning, the claimant continued to incur attendance infractions. As such, the claimant mismanaged her position of employment. We should affirm the AT decision, misconduct, no chargeback.
Affirm the AT, misconduct, no chargeback.
Short form dissent.
Yes, sir.
Case number 3330649, Commissioner Trevino.
The AT decision is not supportable. The employer has a recording they allege includes rudeness by the complainant, but they have not sent that recording to the commission. The complainant's firsthand denial of being rude to a customer should have been given greater weight than the employer's secondhand testimony. Reverse the AT, no misconduct, chargeback, and void the adequate response ruling. Alternatively, I could agree to a rehearing so that the employer can provide the recording of the call in the final incident they allege resulted in the customer's complaint.
All right, we should modify the appeal tribunal decision. The claimant was discharged for unprofessional behavior with the customer after warning for similar behavior. The employer received a recording of the final incident phone call and determined that the claimant's conduct violated policy. Accordingly, we should modify the AT decision, misconduct, no chargeback, sever the adequate response issue. In the alternative, we could rehear this case for submission and review of the recording of the customer phone call that led to the claimant's discharge.
Let me turn that on so you can hear me. Rehear to obtain a copy of the recording of the final incident.
We will rehear the case.
Case number 3333962, Commissioner Dimerson.
We should modify the appeal tribunal decision. The claimant was discharged after the employer reviewed 15 calls spanning several weeks, during which the claimant failed to follow the required script and muted the calls until the customers disconnected. The employer reviewed the recordings with the claimant. She acknowledged that her voice could be heard at the beginning of the calls, but not later in the calls. Although the claimant alleged that she had followed policy and that the system simply failed to record her voice during the end of the calls, this is not credible. The employer testified that this partial recording was not an issue with any other employees. Thus, because the preponderance of the credible evidence established that the claimant failed to follow policy and engaged in call avoidance, she was discharged for misconduct connected with work. We should modify the AT decision, misconduct, no chargeback, sever the adequate response issue.
The AT decision is not supportable. The claimant denied the allegation of misconduct under oath. The claimant testified that she read the dead air script and could not be heard the customer and was not aware of her script was not being recorded by the employer's phone system. A technical issue with the employer's phone system could be a reason the phone system did not record the claimant's reading of the script. The employer's secondhand hearsay evidence is insufficient to prove the allegation of misconduct. Modify the AT decision, no misconduct, chargeback, void adequate response.
Modify the AT, misconduct, no chargeback, sever adequate response.
Short form dissent.
Yes, sir.
Case number 3338672, Commissioner Dimerson.
The appeal tribunal decision should be reversed. The employer provided testimony that the claimant was fired because he did not perform any of the duties he was hired to perform. In addition, the employer testified that the team the claimant was responsible for managing complained that they were not receiving any direction or any feedback from the claimant whatsoever. The claimant did not provide any testimony to the contrary. In sum, the employer's description of the claimant's performance reflects that the claimant was not performing certain job duties, which amounts to the claimant not working to the best of his ability. As such, the claimant mismanaged his position of employment. We should therefore reverse the AT decision, misconduct, no chargeback, adequate employer response.
The AT decision is correct. The claimant was unable to do the job for which he was hired and was never able to perform to the employer's satisfaction. The claimant's inability to meet the employer's standard is not misconduct connected with the work. Affirm the AT, no misconduct, chargeback.
I agree with Commissioner Demerson.
Majority vote is misconduct, chargeback, sorry, misconduct, no chargeback, adequate employer response.
Short form dissent, ma'am.
Yes, sir. And that was the last UI case pulled for additional discussion on docket 4. You should have received the UI short form dissent list for docket 4.
I move we accept staff recommendations on the remaining UI cases on docket 4, except for the cases on which I'm dissenting, as reflected on the UI short form dissent list for docket 4.
Done. Okay. Second, the chairman's motion, except for the cases on which I'm dissenting as reflected in the UI short form dissent list for docket 4.
I concur with Chairman's motion, except for those cases on which I am dissenting, as reflected on UI short form dissent list for docket 4.
Motion passes with the exceptions noted.
Thank you very much.
Thank you. Is there
Thank
any other
you.
item of business come before the commission? Is
Not
there a
here.
motion to adjourn?
So move.
I second the motion.
It's been moved and seconded to adjourn. We're adjourned. Thank you.
Great. Thank you, guys.